Welcome to this online seminar. Yet another initiative organized by the Transnational Economic Law and Dispute Settlement Group, a part of the Center for Comparative and Transnational Law. Today, we will have Dr. Vladyslav Lanovoy, I hope I'm pronouncing that correctly, and he will be talking about the International Tribunal for the Law of the Sea. Just to introduce Dr. Vladislav's profile, he is currently an associate legal officer at the International Court of Justice, and soon he will be joining the Faculty of Law at Laval University in Quebec, Canada, as a professor of public international law. He has extensive teaching experience. He has served as a lecturer at Lille Catholic University and also a teaching fellow at Queen Mary University of London. He holds a PhD in international law from the Graduate Institute of International and Development Studies in Geneva. He is the author of the book Complicity and Its Limits in the Law of International Responsibility, for which he was awarded the 2017 Paul Guggenheim Prize in International Law. He also has extensive experience in international arbitration. He practiced at Freshfields Brookhouse Derringer LLP and at the Permanent Court of Arbitration. His research interests include the law of international responsibility, dispute settlement, the law of the sea, the topic that brings us together today, human rights law, and international economic law more broadly. He's originally from the Ukraine. He was brought up in my home country, in Portugal. He's also qualified to practice law as a solicitor in England and Wales. So Vladislav, very warm welcome. Good morning to you in The Hague. Welcome to this seminar. Thank you so much for joining us, and you have the floor.
Fernando, thank you so much. It's a real pleasure to be with you, we know each other now for quite some time, and it had to be the COVID outbreak that had to bring us together in this virtual format, which is always nice to catch up with old friends, but also to meet a lot of new people who have decided to join this seminar today. And I'm particularly grateful to those among you who perhaps are big fans of tennis, as there is semifinals of Australian Open at the moment. And instead, we're going to be talking a little bit more about some interesting but equally exciting areas, such as the law of the sea and the International Tribunal for the Law of the Sea. And sort of we'll try to kind of think about its 25 years anniversary, which is almost coming later this year, and try to evaluate times perhaps critically, some of its output. Let me try to see whether I can project the slides, and then I will start the presentation. There we go. I hope you can all see it. Yes?
Yes.
Fantastic. Well, so the topic of today is International Tribunal for the Law of the Sea, 25 years on. As Fernando mentioned, my current position is with the International Court of Justice. And so obviously, whatever I will be saying today is strictly in my personal capacity and in no way is a reflection of the views of the International Court of Justice. And I would very much be keen on having a discussion with you. And so please feel free to ask as many questions as you would like. I will make sure that my presentation will not last longer than 45 minutes to an hour, so that we have sufficient time for a discussion. Now, I think, as I already alluded to, it is a perfect timing to have such a discussion, since it was exactly almost 25 years ago in 1996 that the International Tribunal for the Law of the Sea, to which I will refer as ITLOS throughout this presentation, was starting its functions. It is a tribunal which is seated in Hamburg, and it is composed of 21 judges, which are selected on a sort of geographical distribution basis, which we will see later in the presentation, and which are supposed to represent sort of the global the global regime of the law of the sea and be utmost experts in the field. And they are selected by the Assembly of State Parties, and in its current status, there are 168 states parties to the UN Convention on the Law of the Sea, which, as you can quickly grasp, is essentially pretty much the constitution of the oceans. And we have almost more than 2/3 of the international community which is bound by those rights and obligations set out in the convention. Now, I would like to premise the talk by saying the following, and before I even show you the outline of today's talk. Quite often we are tempted, and this is not just something peculiar to ITLOS, but it is peculiar to many other judicial and arbitral institutions. Quite often in legal scholarship, we have people jumping on at criticizing these institutions, criticizing for their jurisprudence, criticizing for the lack of significant output, criticizing for a number of other factors. But what I would like to suggest to you today, to have at the background of your mind as you're listening to this presentation, is that I think we have to be very careful, and we have to have three important caveats in mind as a background context. The first one would be a historical one, in the sense that we have to realize that it is only post 1899 and 1907 Hague Conventions that international law as we know it today started moving towards the idea of institutionalization of some sort of international dispute settlement. It was with that sort of mind that the negotiators of the 1899 and 1907 convention chose preferably arbitration as a means for the peaceful settlement of disputes, and established the Permanent Court of Arbitration, which originally had this idea of actually going to be a first permanent court, which, as we know, of course, did not materialize, and we had to wait until 1920 with the establishment of the Permanent Court of International Justice, and then, of course, its successor, the International Court of Justice in the post-Second World War. In other words, this first caveat means that we have to be very careful historically and contextually thinking how new it is to think about some form of institutionalized and permanent dispute settlement system, and even less so compulsory dispute settlement system. And as we will see in that respect, International Tribunal for the Law of the Sea is part of this amazing creature, which is the UN Convention on the Law of the Sea, UNCLOS, and in to that extent does have, in a sense, that compulsory jurisdiction. Of course, as we will also see, it is very significantly caveated by the number of potential limitations and exceptions that apply. So that's the first caveat I would like you to hold as we go through this presentation. The second one is the institutional one. And that's a very important one with which, in fact, we will start this presentation. In other words, whichever critique or discussion which aims at a level of critique about any dispute settlement system must very carefully take into account the design and the institutional framework in which any such dispute settlement mechanism operates. And as we will see, the UN Convention on the Law of the Sea does set up a truly unique scheme. But at the same time, that scheme has also certain direct implications on the output and what we can expect from an institution such as ITLOS. Third and final caveat that I would like you to keep in mind throughout this presentation, and to which we will return towards the end of it, is the cross-cutting effect, so the comparative approach. Because it is very easy to look in isolation at a particular dispute settlement mechanism, such as International Tribunal for the Law of the Sea, and its 25 years of existence so far. And be like, well, you know, as we will see down the line, the number of cases seems quite limited. Why would states bother to have, you know, such a system, cumbersome system, where they are actually, you know, ensuring that there are 21 judges, but they actually don't seem to resort that often to that system. Now, I would like to frame that comparatively when you look at some other institutions and when those institutions were created and what they managed to do in the first 25 years of existence. And things will become much more relativized down the line once you actually have that, that data in mind. But we will get to it a bit later. So hold on your interest on that. So with these three caveats in mind, dear participants, what we will try to do today is potentially a little bit ambitious. So at some point, I will, you know, try to adjust perhaps some sections, but I will try to get as much as of this outline as possible. So first, we will briefly look at the origins of ITLOS and the role which is assigned to ITLOS under UNCLOS. So I will be referring, just for the ease of reference, to UNCLOS, meaning the UN Convention on the Law of the Sea. We will have a very brief analysis of Part 15 UNCLOS, which is the part dealing with dispute settlement, peaceful settlement of disputes relating to interpretation and application of the convention. Now, that is extremely important. And of course, I will not bother you with all the details and all the jurisprudential developments that have happened under Part 15. But it is very important to understand the intricacies of that part, because they are directly connected to us being able to objectively evaluate the output of ITLOS. Then we will quickly have a look at the requirements for access and jurisdiction before ITLOS, both contentious and advisory. We will have a look at some of the aspects of the procedure of ITLOS, and then we will proceed to evaluating ITLOS's contributions, both substantively speaking, in terms of development and clarification of the rules and obligations and the law of the sea, but also procedurally, because that's where I think ITLOS, you know, having been born with, I wouldn't dare to say big brother, the International Court of Justice, but a brother who has been in existence much longer, has in fact shown a proclivity to changing and adapting its rules quite often at a faster speed even than the International Court of Justice. And therefore, I think there is an interesting phenomenon happening here, where I think ITLOS is also to be congratulated for a number of those innovations, which I will touch upon later. And finally, we will just finish with the overall evaluation of the output of ITLOS to date and some of the existing and future challenges that lie ahead. So let me just briefly situate you. I already situated you in terms of the general development of dispute settlement, if we think about international law more broadly. And we see that trend towards institutionalization of some level of creation of permanent institutions for peaceful settlement of disputes, starting at the turn of the 19th to 20th century. Now, law of the sea broadly is one of the oldest and most foundational branches of public international law. In fact, many would probably dare to say that it is as old as international law itself. And in fact, if you go back to the old writings of Grotius, you see that in 17th century, law of the sea was at the very heart of many disputes and misunderstandings and potential conflicts emerging between states. And the two ideas, the two confrontational ideas, i.e. of attempt of many states who were interested in exploring the world out there, of having jurisdictional control over certain areas of maritime spaces vis-a-vis those states who wanted to have more say and wanted to have the liberty and freedom of navigation recognized to their vessels. Those, as you will see actually, when you analyze the UN Convention on the Law of the Sea, you see that those kind of tensions are there. Of course, the tensions over time have multiplied, and we can, nowadays consider many more tensions than just that simple equilibrium. But that's essentially what the convention is trying to strike. Now, in the 1950s, when we had the very beginnings of the global legal order as we know it today, post the adoption of the UN Convention on UN Charter, the International Law Commission, the subsidiary organ of the General Assembly, which has been entrusted with codification and progressive development of international law, had to pick a number of sort of key topics on which it had to try to prepare conventional instruments which would codify the existing customary international law. And law of the sea was, of course, one of the very first option in line. And as a result of those negotiations, which then they're brought to the diplomatic forum, four conventions were adopted in 1958 on specific areas, maritime areas. So for example, territorial sea and contiguous zone, the continental shelf, the fisheries. And importantly, in addition to these four conventions of 1958, an optional protocol on compulsory settlement of dispute. Now, that optional protocol on compulsory settlement of disputes, of course, was left to states joining it freely. And as a result of joining it, those disputes, which are covered by the conventions, would be going directly to the International Court of Justice. And as you can imagine, there aren't that many member states or states who have actually ratified that optional protocol. We have less than 40 states. And the idea was, well, we can't just commit to something which is not one global instrument where we can see all the different substantive obligations that we have, and then at the end have a proper dispute settlement chapter so that we know exactly what is our leverage. And that is something that in 1982, at the moment of the adoption of the UN Convention of the Law of the Sea, was one of the key elements in the head of negotiators. The idea that you cannot just have a piecemeal approach to the law of the sea. What you need is to have one global instrument which will also have as an integral part whereof a dispute settlement system integrated in it. And that was real, sort of the real groundbreaking effect of the negotiations which took place from 1972 until 1973 until 1982, when the convention, the UN Convention on the Law of the Sea, was adopted in Montego Bay. So that dispute settlement mechanism, that part 15 of UNCLOS, if you wish, is the jewel of the entire convention, of the entire constitution of the ocean. The idea that when you as a state, you ratify this instrument, you ratify this you are supposed to comply with a host of obligations set in this convention. And should the dispute arise, there is a proper system of dispute settlement, which, as we will see, has arrived at a perfect balancing of, on the one hand, allowing for states the freedom to choose. As you know, the choice of means being one of the fundamental principles in the context of dispute settlement. And on the other hand, have an integrated system, and a system which essentially provides for default options in situations where either the choices made by two disputing parties do not coincide, or they have simply been silent and decided, well, we will not say anything on where we would like this dispute to go. And as we will see, this has, of course, the automatic impact on the ability of ITLOS as a permanent institution to also thrive in such a system. We will basically now proceed to have a very quick overview of Part 15, which constitutes an immediate context in which ITLOS has to perform its functions. What we will try to see very briefly is that Part 15 is divided essentially in three main sections. Section 1 provides for what I would call voluntary dispute settlement procedures. It is only if those voluntary dispute settlement procedures, such as negotiation or voluntary conciliation, do not lead to the result, of course, being the peaceful settlement of that dispute, then there is basically a next stage, which is the compulsory procedures for dispute settlement, which will lead to the binding and final decision, which the parties have to comply with. That, of course, is all very nice, but the negotiators of the UNCLOS 3 conference, which led to the adoption of the convention, had also in mind many of the worries that this will really result in a fully compulsory system of dispute settlement over all types of disputes arising under the law of the sea. And as a result thereof, they wanted to carve out certain types of disputes from this compulsory system of dispute settlement. And we will see very briefly those carve-outs. And then finally, there are other parts of the UN Convention on the Law of the Sea which are relevant, namely the so-called seabed disputes chamber, which competence of which is regulated by Part 11, Section 5 of the Convention, as well as a number of annexes which provide for the procedure applicable to conciliation. As I mentioned to you, under the convention, there is the possibility for the voluntary conciliation, but also for the compulsory conciliation. And as you may have been aware, recently there has been the very first compulsory conciliation successfully concluded between East Timor and Australia. And then also other annexes which provide for the procedure of the arbitration tribunals which may be set up under the convention. And that is essentially the Annex 7 arbitration, to which we will refer quite a lot, which provide for the general competence of tribunals set up in this way, and the idea of the special arbitration, which was also incorporated into the convention, but to date has not seen the light of day yet, which is only dealing with very specific types of disputes, such as fisheries, for example, or heavily technical or scientific disputes. So if we want to kind of recap and have the idea of what this UNCLOS Part 15 is, in which ITLOS is inserted, it is almost science fiction if you really think about dispute settlement overall in international law, which, as you all know, is based on the fundamental premise of consent. In other words, unless me as a state, I don't consent, of course, nobody will be able to entertain the dispute, and least so to actually give a ruling which would be final and binding. And this is the beauty of UNCLOS Part 15. It is a specialized dispute settlement mechanism in the sense that all of those means of dispute settlement and all those fora which are listed in Article 287 only can deal with disputes concerning the interpretation or application of UNCLOS. So you can see here that we are not talking about a global compulsory jurisdictional mechanism. We are only dealing with certain categories of disputes. It is, however, compulsory because unless you fall within those very few specific, what I would call automatic limitations or optional exclusions of certain categories of disputes, then you are in. Once you have signed and ratified the convention, you expose yourself as a state to the risk that down the line, should a dispute arise, you will be forced to take part. Of course, you can decide not to take part, but you will be forced by the ultimate decision, which will be rendered by one of those compulsory dispute settlement procedures. Third, it is integrated. As I mentioned, it is an integral part of the convention, so it's automatically binding upon states parties. Fourth, it is flexible because, as we will see briefly, the convention allows for two types of declarations to be made by states. One, declarations on the choice of forum. So, as you already realized, there is a list of different means of dispute settlement provided by the Convention's Article 287. And states are able, at the moment they adhere to the Convention, sign or ratify it, to actually indicate which means they would prefer for the settlement of any disputes that would arise in relation to interpretation or application of the Convention. And in addition to this ability to choose where to settle the dispute, they can also, and this is completely optional, they can also make the so-called Article 298 declaration, which allow to exclude three specific types of disputes from the compulsory jurisdiction of the mechanisms foreseen in Part 15. And finally, it is efficient to the extent that it strikes this really right and sound balance between voluntary and compulsory procedures for dispute settlement. So I will just flag out some of the absolutely key provisions of Part 15. So of course, here we have Articles 279 and 280, which reflect the idea that states parties shall seek to settle any disputes between them by peaceful means. And of course, they would be entitled, the recognition comes here of the principle of the free choice of means, as you can see towards the end of Article 279. And this idea that the parties still are left with the control to the extent that they are allowed by the convention to indicate which specific means of dispute settlement they might choose. But to counterbalance that, the drafters of the convention getting together in Montreux over a nice weekend over the lake, and they managed to come up with a brilliant solution, which is, well, let's have this a full list of different means of dispute settlement, but let's provide for the situation where either the declarations being made do not match. So, for example, one of the future potential disputing parties would say, I prefer for any such disputes to go to the ICJ. And the other would say, I would prefer to go to ITLOS, this newly inaugurated tribunal. And in that situation, the drafters of the convention envisaged that by default, it would be Annex 7 arbitration that would apply. Now, I will not get into the intricacies of those discussions, but this choice of the default mechanism had a number of sort of background explanations. And I think it is a right choice to the extent that, as you all know, arbitration does allow quite a lot of flexibility to the parties, and there is some scope to reconcile their interests, at least procedurally speaking. So what is important for our purposes, and this is where I'm gonna try to make a link as well, is that before you get to that compulsory procedures, which are set out in section 2 of part 15, of which of course ITLOS is one of them, we have seen a huge amount of jurisprudential developments coming also from ITLOS, but also from other mechanisms, in particular Annex 7 arbitration tribunals, on the preconditions that in fact need to be satisfied before, before one can resort to compulsory procedures of section 2 of part 15. And essentially, to summarize very, very, very impressionistic terms, you would have to have a situation where there is no binding agreement between the parties expressly precluding compulsory procedures of the convention. And this is where the tribunal in the South China Sea arbitration has interpreted quite and given quite a significant clarification of the application of this provision of Article 281. Second, there should be no agreed procedure that would entail a binding decision. So the perfect illustration of this is the situation where, for example, two states may have made optional declarations under Article 36, paragraph 2 of the ICJ statute. And in that circumstances, if those two declarations match, and the ICJ, of course, would be perfectly competent to proceed and to study that case. And in a sense, that would trump the normal application of Part 15 of how the dispute would go from voluntary towards compulsory mechanisms foreseen in Section 2. For that, of course, you can read a very interesting clarification on this point that the Article 36(2) of the ICJ statute declarations may be considered as the otherwise in the Article 282. So I would invite you to read the preliminary objections judgment of the ICJ in Somalia, Kenya. And finally, there should have been an exchange of views between the parties. And here, ITLOS specifically has made quite a significant contribution on what this entails, this obligation of exchanging views between the parties, that in essence, it should not be an indefinite duration obligation, that of course, if the other party is clearly unwilling and silent to have any exchange of views, at some point you can proceed to compulsory procedures of dispute settlement. And so also the other arbitration tribunals have clarified the scope of this obligation in the sense that the exchange of views does not need to relate to the specifics of the dispute as such, but it has to relate just mainly to the means for the dispute settlement and the fact that whether the parties have exchanged views on where such dispute could be settled. And the Article 287 makes this connection between the voluntary procedures, which are allowed as a first instance for disputing parties, and the Section 2 procedures, which are compulsory in character. And of course, it caveats them to what comes in Section 3. And as I mentioned already earlier, there we do find two of the most complex provisions drafted in an extremely ambiguous way, which set out the so-called automatic limitations to compulsory dispute settlement and also certain optional exclusions which states parties may avail themselves of. So here we go. The 287 is that chief provision which lists all the different means that the parties to UNCLOS can choose from in their declarations. And of course, I'm just showing you here paragraph 1 of that provision. The subsequent paragraphs do set out that the default procedure in case of mismatching declarations by two disputing parties or in a situation where they have made no declarations would be Annex 7 arbitration. So at this point of my presentation, I imagine your minds are, okay, now I really get it, why there have been 15 cases before Annex 7 arbitration in relation to the law of the sea, whereas maybe the case count, as we will see before ITLOS, that of 29 cases in total, could now be more counterbalanced. And you can already see here the institutional constraints which are built within the convention itself. So just to give you an idea in terms of those choice of forum declarations, 125 out of 168 state parties have not made their choice. In this situation, of course, it would be default Annex 7 arbitration, which would kick in. 19 have chosen ITLOS, 7 have chosen the ICJ, 5 have chosen Annex 7 arbitration, 12 have chosen both ITLOS and the ICJ. So looking at these sheer numbers, you understand quickly why there has been so many more cases in recent decades after the convention entered into force in 1994, going to Annex 7 arbitration rather than to other mechanisms such as the ICJ or ITLOS. Now, of course, you would be thinking here, well, but hold on, the ICJ has had quite a lot of cases of maritime delimitation in recent years. Yes, but all of them were not brought on the basis of the UN Convention on the Law of the Sea. They were brought either on specific compromissory clauses in regional treaties or on the basis of matching optional clause declarations under the ICJ statute. So you can see from here that essentially that Montreux solution is very much alive, and perhaps in terms of the numbers themselves, maybe, as you can see here, the picture on the top of the arbitral tribunal in Guyana, Suriname, is actually the key mechanism and the most successful mechanism to date. Now, again, this is the institutional constraint, and we will see how ITLOS has nevertheless made a very significant contribution to the law of the sea and to general international law more broadly down the line. So let me cover very quickly also some other provisions of Part 15, namely that, as I mentioned already, the jurisdiction of any court or tribunal under Article 287 is that over disputes concerning the interpretation or application of this convention. But also, and this is important, it also has jurisdiction over any dispute concerning the interpretation or application of an agreement related to the purposes of the convention, which is submitted to it in accordance with that agreement. And there has been, after the adoption and entry into force of the UN Convention on the Law of the Sea, many regional instruments which provide for such ability to actually recognize the jurisdiction of Part 15 mechanisms. And these have been in specific areas which are nonetheless connected to the matters governed by the UN Convention on the Law of the Sea. And of course, any of those decisions, as is the fact with other dispute settlement mechanisms, which you may be familiar with, are final and binding. And Article 296 recognizes that point and also recognizes the relative force of those decisions, which of course are only binding as between the parties. But as I mentioned, the quid pro quo for having such a unique system was to make sure that certain types of disputes are caveated, are accepted, if you wish, from the purview of the compulsory dispute settlement system. And therefore, we find these very difficult and convoluted provisions in Articles 297 and in particular in 298. So the 297 provides for those automatic limitations. So certain types of disputes which are automatically excluded from the compulsory dispute settlement. In essence, and of course I'm terribly simplifying here, these are disputes relating to the marine research, marine scientific research, to specific projects on the continental shelf, or that the coastal state may, deny in certain circumstances, and disputes mainly relating to fisheries in the exclusive economic zone. Now, of course, there are exceptions to these exceptions, and there is ability still to come with these disputes towards a compulsory conciliation, but I will not get into those extreme details, but just be aware that even in the case of such disputes as for example, those relating to fisheries in the exclusive economic zone, in certain specified circumstances, you could still have a backdoor into the conciliation as a mechanism for settling such disputes. And then there is 3 types of disputes which the parties may exclude from the purview of a compulsory dispute settlement. These are disputes concerning maritime delimitation and involving historic base or titles, disputes concerning military activities and certain law enforcement activities in the exercise of their sovereign rights, for example, in jurisdiction, and for example, in their exclusive economic zone, and disputes in respect of which the UN Security Council is exercising the functions assigned to it under the UN Charter. Now, there is today, and this is maybe surprising as well, only around 40 such declarations being made. Some of those declarations exclude all these 3 types of disputes, but they are certainly a minority. Many exclude just one type of disputes, quite often those relating to maritime delimitations. So in other words, that state who has made such a declaration, it cannot be bound to proceed to the compulsory dispute settlement mechanism, which are listed in section 2 of part 15, and they can basically exclude that kind of disputes. So you can see here an important limitation, practical limitation, also in terms of disputes which may be considered. But at the same time, it is quite reassuring that there, out of 168 states, there is only 40 who have made such declarations. Now, of course, don't forget that there are many states who are landlocked states and don't have any maritime spaces. So of course they have no maritime delimitation issues with their potential adjacent or opposing states, neighbors. So you can see here that maybe the fact that there have been so few declarations doesn't necessarily mean universally that they haven't had a significantly limiting effect. So this is the extremely important institutional context. And now things that I'll be telling you from now on will become much clearer, having in mind that institutional background. So ITLOS was established at the time as one of the additional means for settlement of disputes relating to interpretation and application of the convention. It has its seat, as I mentioned, in Hamburg. Nevertheless, the tribunal over time has worked on its ability also to have some of its potential hearings elsewhere. And for example, it has concluded a joint agreement with Singapore for eventuality of one day perhaps to have hearings in Singapore. And the statute does allow the tribunal to have hearings in places other than Hamburg, which is interesting here because it sort of picks up on an element which is usually akin to arbitration. The composition, as I mentioned, is 21 judges, so more judges than, for example, at the ICJ, and the distribution is slightly different. There should be, according to the statute, no less than 3 judges from each geographical group, as geographical groups following the nomenclature of the United Nations. We do have also the ability of ITLOS to function in chambers, and there have been various of these chambers established over times. The parties, of course, may also agree to special chambers. So you could, for instance, pick some of the judges of the 21 to constitute the special chamber to deal with your dispute. And of course, as I mentioned to you earlier, there is the seabed disputes chamber, which plays a key role in the legal regime which governs the area being the space, the seabed, the deep seabed beyond areas of national jurisdiction, which is governed by the International Seabed Authority. That's the governance mechanism that the UN Convention of the Law of the Sea provided for. And let us quickly look at some of the most relevant aspects relating to access and jurisdiction of ITLOS. So as I mentioned, states and other entities may become parties to the convention. To date, of course, we only have 167 states and the European Union, which is a party to the convention. Of course, it may also become available, and this is the very interesting development that has been happening. It may be available to those parties who are not even parties to UNCLOS, but who are in fact parties to other agreements relating to the law of the sea, which provide for the jurisdiction of ITLOS. So the best example is, of course, the UN Fish Stocks Agreement, which provides in Article 30 that, in essence, in the settlement of such disputes, the mechanism of Part 15 would apply mutatis mutandis to any dispute in relation to that specific agreement, i.e. to the UN Fish Stocks Agreement. Now, this is particularly interesting because, in essence, you would have the same Part 15 applying to a much wider, potentially, pool of participants. So just to give you a clear example, the United States, for instance, is party to the UN Fish Stocks Agreement. But of course, as you know, it is not party to the UN Convention on the Law of the Sea. So in such situations of a dispute arising, for example, between the United States and some other state, you would, via this UN Fish Stocks Agreement, basically settle that dispute in accordance with Part 15 of UNCLOS. Now, in terms of contentious jurisdiction, maybe I will try to sort of go a little bit faster as I see my time is going. But in terms of contentious jurisdiction, again, this is just, it is limited to disputes concerning the interpretation or application of UNCLOS, but also to those disputes that relate to other agreements related to the purposes of the convention. As I mentioned earlier, the Seabed Disputes Chamber, of course, deals exclusively with disputes with respect to the activities in the area. But what is particularly exciting as a development in recent years was the way in which, and this is different instruments, which, as I mentioned earlier, the way in which the ITLOS has been at the forefront of explaining why it also has general competence to give advisory opinions. Now, this is a particularly exciting legal development because, in fact, there is nothing expressly in the ITLOS statute providing it with this general competence. As you can see on your screens, Article 21 of ITLOS statute speaks of all disputes and all applications submitted to it under the convention, and then adds, and all matters specifically provided for in any other agreement which confers jurisdiction on the tribunal. Now, in the 2015 very first advisory opinion delivered by ITLOS in its plenary, so ITLOS as a tribunal, of course, we had the CBAD dispute chamber advisory opinion in 2011, but in that 2015 advisory opinion, the tribunal made an important clarification in interpreting all matters specifically provided for in any other agreement as constituting a sufficient legal basis, together with Article 21 of its statute, for recognizing its general competence to give advisory opinion. Now, it's interesting that, of course, Article 138 of the rules of procedure of ITLOS very quickly, of course, before even this advisory opinion, explained this apparent oubli, I would say, apparent forgetfulness of the statute in not setting out clearly the advisory function of ITLOS. So, of course, we can question as to whether the interpretation made by ITLOS is a persuasive one, and there has been significant scholarship published on the subject and scrutinizing the reasoning of ITLOS on this point. And finally, in terms of applicable law, Article 293 of the Convention provides that ITLOS would apply this convention and other rules of international law not incompatible with the convention. And here again, there have been a lot of interesting jurisprudential developments over the last 25 years. ITLOS, in fact, has often relied on other international law instruments in its cases. In particular, the line of jurisprudence followed from its very first judgment in the MV Saiga between St. Vincent and Grenadines and Guinea shows how ITLOS has been, in fact, open-minded to seeking elements of applicable law outside the four corners of the convention. In particular, for example, on understanding the reasonableness of the use of force applied by the Guinea enforcement authorities over the vessel. And here, perhaps a contextual reference framework is that the convention itself, in Article 301, refers to the prohibition of the use of force against the territorial integrity or political independence of states, but of course says nothing specifically about the use of force in the context of enforcement activities by the coastal state. And in that respect, it is quite significant that ITLOS started this line of jurisprudence, which in fact was picked up by a number of early arbitral tribunals, which went to the point of really abusing, I would say, the Article 293 as the applicable law provision. And even in Guyana, Suriname, we had in the dispositif, in the actual operative clause, a declaration by that arbitral tribunal that it had jurisdiction to rule on the question of the use of force by the Surinamese authorities. And therefore, in essence, it pronounced on a claim in respect of legal rights and obligations which are nowhere expressly set out in the convention. But of course, there are also many other instances where ITLOS has legitimately looked out for the contextual general international law environment in understanding and interpreting some of the provisions expressly contained in the convention. And this initial sort of outbreak of perhaps expanding too much the applicable law provision has pretty much been put to end with the more recent arbitral awards, such as Arctic Sunrise or Dusgit arbitration, where clearly the tribunal said, well, it's all fine. We can look at the general corpus of international law to try to interpret some of the provisions in UNCLOS. But what we certainly cannot do is to pronounce ourselves on claims based on legal obligations which are clearly not set out in the UN Convention on the Law of the Sea. But we still await ITLOS's judgment, which will perhaps put a final point to this interesting and challenging discussion. Now, the importance of ITLOS has also to be understood from the two specific elements as part of its jurisdiction and as set out in the UN Convention on the Law of the Sea, the ability of ITLOS to prescribe provisional measures. As you remember, in situations where you don't have matching declarations and, for example, arbitral tribunal is about to be established, there is quite often situations where the parties need to seek that emergency relief to protect their rights pending the constitution of the tribunal. Or, for example, imagine there is an urgent situation of environmental spillage, for example. In that kind of case, you want to have an immediate relief. So that's provided by provisional measures, applications that can be made to ITLOS under Article 290. And the other extremely interesting mechanism, which is that of prompt release of vessels and crews. And here again, ITLOS has developed quite a significant line of jurisprudence, because if your vessel is detained by the coastal state for example, infringing some of its regulations in relation to the activities, let's say the fisheries regulations in its EEZ, you are brought to the shore, you are detained, your crew is detained, your cargo may be precious, you want to get that immediate release of the vessel, even because, as you know, the proceedings that will, for example, criminal proceedings, which would be initiated in the coastal state, may take years, which of course will cause an unbelievable prejudice to the ability more generally to have a free navigation. And this is the mechanism which is provided under the convention and which has proven to be extremely successful. I will skip over, different conditions which are necessary, for example, for obtaining provisional measures and prompt release. What I would say is that ITLOS has definitely made a significant contribution in this respect and has fully aligned over time its jurisprudence with that of the International Court of Justice in respect of the conditions which are necessary to be satisfied for provisional measures. In particular, following Ghana Cote d'Ivoire provisional measures order of the Chamber of ITLOS, it is clear that, for example, ITLOS has taken up the same plausibility test as developed in the ICJ jurisprudence. So we can see here a cross-fertilization, if you wish, which again immediately makes us doubt about some of the early positions expressed in the 1990s that this buffet option of different mechanisms for settling disputes relating to the interpretation and application of the convention would lead to fragmentation, which I think is a pretty a real overstatement, because the reality and the practice that followed has showed us that that was more of an artificial problem rather than the real problem that has happened, at least speaking in respect of the law of the sea disputes. So I will get over this because I can see that my time is almost expiring, so that I can get through. And of course, in terms of rules and procedures of ITLOS, I think what is really interesting to point here is that, of course, they have been largely modeled on the ICJ rules, but there is quite a number of interesting and subtle differences. In particular, for example, the ability of ITLOS to have summary dismissals of ill-founded applications, or in terms of who may have legal standing, for example, to bring applications for prompt release of vessels and crews, or the fact that ITLOS has over time developed a rather stringent approach to the filing timelines. So, for example, to give you one comparison point, any preliminary objections in the context of ITLOS must be made in writing within 90 days from the institution of the proceedings. Now, contrast that, for example, with the ICJ position, where, of course, it's only after the claimant has filed a memorial and the respondent has to produce a counter memorial. That's the moment where it would have to raise any preliminary objections. In other words, clearly, if you were to just look procedurally in the ICJ context, you as a respondent, you would have a much more comfortable timing, at least, to think of various preliminary objections that you would want to raise as compared to the ITLOS context. Another area where it's extremely exciting, the slight nuance differences between the practice of ITLOS and the ICJ has been in respect of the amicus curiae. We have had very little practice so far, but in the context of such requests made by Greenpeace, of course, the tribunal followed the same approach as the ICJ, setting out that such unsolicited submissions would not form part of the case. Yet, the tribunal did communicate such amicus curiae submissions to the parties and even published on the website of ITLOS. So let us take another 5 minutes. If Fernando, if you indulge me to have another 5 minutes in total, I have only 4 slides left, and then we could maybe open to.
Sure.
Fantastic. So now that we have seen and sort of have this strike over different institutional aspects and also more pragmatic aspects going to the jurisdiction to and applicable law and access to ITLOS, what has been its output in 20 years of existence? And I think the numbers on the screen speak loud, but I think, again, let us put these numbers in context. So we've had 27 contentious cases, including 2 pending cases, one between Switzerland and Nigeria, and one between Mauritius and Maldives, in which the tribunal has recently rendered its judgment on preliminary objections. We have had 2 advisory opinions, 6 merits judgments, 2 on delimitation, 4 on vessel detention and release, 2 judgments on preliminary objections, and mostly, as you can see, a number of what I call residual jurisdiction of ITLOS, namely in respect of provisional measures orders and prompt release orders. And that's where I think ITLOS's jurisdiction has been most successful, of course. But if you actually think about this from a comparative perspective, perhaps this sheer looking at the numbers is actually not as bad. If you think about ICSID, for instance, in the first 25 years of ICSID, from 1972 until 1997, you had 38 cases filed. If you think about the ICJ in the first 25 years of its existence, from 1946 until 1971, you had 53 cases. Of course, you would reproach to me and you would say, but what about, for example, places like WTO, which started in 1995 and which by now has 600 cases? Yes, I mean, if you put this all in perspective, I think that the numbers, and once you have that institutional background knowledge in mind, and the idea that the drafters originally wished for Annex 7 arbitration to be the default default means of dispute settlement, actually numbers become relatively relatively positive. You know, of course, you could also say, well, most of these decisions are, if you wish, incidental decisions. They are not really decisions on the merits. And so we would have hoped to have many more delimitation cases before ITLOS, and cases in relation to specific obligations found in the convention. But it's also important to relativize this, because in many of the cases where ITLOS rendered provisional measures orders, it actually led to a settlement, to the amicable settlement down the line between the disputing states. This was the example of the land reclamation case between Malaysia and Singapore, which was going to Annex 7 arbitration. And after the provisional measures order of ITLOS, the parties were able to have a settlement, and the tribunal, the arbitral tribunal, simply had to incorporate that settlement in its decision. So what can we say about substantive and procedural contributions of ITLOS and its output? I think there is a number of things that we could talk about, but I would highlight the fact that ITLOS has clearly contributed to our understanding of the concept of the continental shelf and the delimitation of the outer continental shelf, in other words, that extended shelf beyond 200 nautical miles from the baselines. And this was the very first time that any international court or tribunal went on to make that delimitation beyond 200 nautical miles. This was in Bangladesh Myanmar case. ITLOS has, in its seabed chamber, has clarified the duties that states have when sponsoring contractors in matters of exploration, exploitation of resources in the area. The seabed advisory opinion was an incredible opinion, clarifying some of the direct obligations that states have and some of the due diligence obligations that they have in this respect, as well as the liability regime which would apply. ITLOS has massively contributed to understanding the regime which applies to vessels, the flag state principle, and the requirement of genuine link between the vessel and the flag state. It has also made a significant clarification of the duties that states have in respect of illegal, unregulated, and unreported fishing when they are engaging in such fishing in the exclusive economic zone of third states. And this came out very clearly from the 2015 advisory opinion. It has also clarified the duties of states in respect of many of the activities which were not expressly foreseen by the drafters in the UNCLOS, such as bunkering, which is essentially fueling oil to vessels in the exclusive economic zone of some states, and whether that could come within the purview of the coastal state ability to take measures in the conservation and management of marine living resources. It has also picked up on some of the important developments happening more widely in international law, such as the understanding of what due diligence obligations require, as well as embracing the precautionary approach, for instance, in its southern bluefin tuna provisional measures order and in the seabed advisory opinion. In terms of procedural contributions, it has certainly clarified some of the specific provisions in Part 15, namely in that voluntary section of Section 1. It has clarified the relationship between different sources of jurisdiction that ITLOS has, and the fact that it has a general competence to give advisory opinions. It has consolidated a consistent line of jurisprudence on provisional measures, aligning itself with, following Ghana, Côte d'Ivoire, for example, with the jurisprudence of the International Court of Justice. And it has very significantly clarified the conditions and scope of prompt release under UNCLOS. This mechanism, its operation, what would constitute the reasonable bond, financial bond, which is required. So in essence, the flag state has to deliver that bond to the detaining state of the vessel. So in 2 or 3 words to finalize, what are then existing and future challenges? Well, what we seem to be seeing is that more and more we have cases which originally should go to Annex 7 arbitration, slowly but steadily transitioning to ITLOS. We've seen that in a number of cases such as Bangladesh, Myanmar, Ghana, Côte d'Ivoire, or Switzerland, Nigeria. We also see more and more disputes which are inextricably connected with questions of territorial sovereignty, which are, of course, outside the scope of jurisdiction of dispute settlement mechanisms under UNCLOS. That is another huge area for debate. There have been some pronouncements of arbitral tribunals, such as in the MPA decision on Chagos, where the arbitral tribunal said, well, you know, it is not excluded that one day there could be incidental issues relating to territorial sovereignty on which we would still be able to give a determination, even though clearly the jurisdiction, as we've seen, is limited to disputes relating to interpretation and application of the convention. And finally, there is this proclivity to perhaps apply excessively the applicable law provision in the UNCLOS, and therefore we still have to see what will happen in the future jurisprudence. In addition to, of course, the fact that we see more and more regional treaties which confer jurisdiction on ITLOS and which may, down the line, expand the number of its cases. So all that to say, all ways lead to ITLOS? I'm not sure. I'm not sure we can say that. But we certainly see that there is, despite the numbers, which are limited maybe, but again, as I mentioned, we need to have this cross-institutional and intra-institutional understanding. There are many advantages in bringing cases to ITLOS, such as cost efficiency, excellence of its facilities, procedural efficiency. We see that cases on average take around 2 years from the beginning to the end, if you wish. That's a pretty good mark to have. We also see quite a few innovative and practical solutions that ITLOS itself came up with, namely in Bangladesh, Myanmar, in the context of delimitation of the continental shelf beyond 200 nautical miles, as well as in the interesting ways of adapting the scope of provisional measures. So for example, in Ghana, Côte d'Ivoire, it said, well, in those drilling that has already become, you know, where the production of oil has already become, of course, that is accepted. But from that moment on, all new drilling would be subject to the provisional measures that ITLOS decided to prescribe. We also have something quite significantly perhaps different from some other mechanisms, is a very robust follow-up mechanism for the implementation of ITLOS's orders on provisional measures. And finally, looking forward, my understanding is in the most recent discussions in the ongoing negotiations concerning a new legal instrument on biological diversity in areas beyond national jurisdiction, there has been debate as to whether time is not ripe to set up ITLOS as a default mechanism in future disputes which would arise in respect of BB&J, as opposed to Annex 7 arbitration. Now, of course, that is only negotiations for the time being, but there is certainly, for many of you who are young and willing to embark on a journey of international dispute settlement, there is a huge variety and quantity of cases looming ahead of you. And I would very much encourage you to consider law of the sea and dispute settlement more generally as your careers. Thank you so much.
Thank you so much, Vladyslav, for this excellent presentation. We'll move immediately to the Q&A session. I received a question from Benoit. Benoit, would you like to unmute yourself? Are you able to do so? No? Okay, in that case, Ellen, can you unmute Benoit? If not...
Yeah, okay. Can you hear me?
Yes. Yes.
Yeah, thank you. Thank you very much for a very interesting presentation, very informative. Benoit Meyer, I teach climate law at CUHK. And so my question is actually about climate law. So I've heard in some environmental law circles about a proposal at the moment of perhaps one day requesting an advisory opinion of ITLOS on the obligation of states to mitigate climate change. That will be based on Article 192 on the prevention of pollution to the marine environment. And the strategic advantage would be, compared with the ICJ, the jurisprudence of ITLOS in sub-regional fisheries commission on allowing an organization of a few states to request an advisory opinion, which is easier than the majority of the General Assembly for the ICJ. So I wonder if you have heard about those discussions, whether this is discussed in Hamburg at all, and what you think of the feasibility and the likelihood of judges jumping on this opportunity.
Thank you. No, I have to confess, I haven't heard about any specifics in relation to this attempt to bring a request for an advisory opinion. Now, of course, as you're well aware of the 2015 advisory opinion, in that case, as you say, in the regional context, number of states were able to bring such a request. And I don't see why that would not necessarily be possible in the context of a particular regional treaty, which would confer such jurisdiction to the tribunal. You would have to think which regional treaty you would be basing yourself on. As you rightly say, yes, Article 192. Now, the problem is with the entirety of Part 12 is that it's sort of a framework, if you wish, as you know pretty well. It's a framework set of obligations which are then supplemented by the elaboration of legal standards and obligations which may be elaborated in various regional fora. And so, of course, it could be extremely interesting if on a purely procedural and jurisdictional hoop, such states would be able to bring this request. I think it could give rise to a very interesting jurisprudence complementing our understanding of Part 12, part dealing with the marine environment. Let's hope that this will happen one day. But I definitely see the benefit of having an advisory opinion clarifying some of the legal challenges, in particular in relation to the multiple ways in which climate change is currently affecting the law of the sea regime, and which was not foreseen at all by the drafters back during the period of the UN Convention on the Law of the Sea conference. One area in particular where I think there's a lot to be said is that of sea level rise, which, as you know, right now is subject of a study conducted by the International Law Commission. I think that's what I will say on the subject.
Okay. Another question that we received through the chat box. A question from Debbie Fu. The question is the following: is the inception of the seabed disputes chamber a result of China leading the race in exploitation of deep sea mining activities? Is the appointment of Judge Duan Ji Long to ITLOS a way to promote ITLOS in this controversial arena?
So on the inception part, I don't know what you exactly mean by the inception, but obviously the seabed chamber being part of Part 11, and as you know, Part 11 was quite the sticking point at the final stages of the negotiation of UNCLOS. We had to wait to have that implementing agreement in 1994, which allowed for Part 11 to remain, as fully part of the this package being UNCLOS. And of course, at the time, the challenge was how to reconcile interests of both developed states who had the technology to do such exploration and exploitation in the seabed, in the deep seabed in the area, and their unwillingness to share some of that knowledge and that technological know-how with other developing states, which of course wanted to have a piece of the pie. So I'm not sure that when you're talking about the inception, clearly it wasn't any sort of specific states. At the time was more the United States, which was at the forefront of this idea that we would like to oppose this and we would like to have significant amendments to Part 11 before the whole thing comes into force. And of course, ultimately down the line, the United States did not become party of UNCLOS, as you know. So I'm not sure, the first part of the question. Now, on the nomination of in the recent election of the Chinese judge, I don't see how that specifically would have a direct or indirect impact on the legitimacy of UNCLOS, but I think it's important that it's important for all states to continue very much engaged in the legal regime set up by the UNCLOS, and now judges, as you know, once they are elected, they are fully independent and impartial under the statute, and so it's just a matter of properly applying the law as it is in this beautiful book. That's what I would say at this stage. I'm not sure I answered your question, but
okay, thank you. We also have a question from Massimo Lando. Ellen, could you please unmute? In the meantime, while we are...
I think I'm unmuted. Thank you.
Yes, you are.
Thank you. Massimo Lando, City University of Hong Kong. Vladyslav, I wanted to ask you a question concerning the competition between the ICJ and ITLOS in the domain of maritime delimitation. Now, despite ITLOS being a specialized court in the law of the sea, the ICJ has been seized of many more delimitation cases than ITLOS has since 1996. And I just wanted to get your idea as to why that is in your view. Why has the ICJ persisted in being a preferred forum for maritime delimitation cases over the more specialized ITLOS? Thank you.
Yeah, thank you, Massimo. It's a good question. I think it's historical reasons, obviously, as the convention was still sort of at the very early stages of its negotiation. Quite a number of significant decisions of the ICJ actually allowed the negotiators to kind of speed up the process of even coming with certain concepts such as exclusive economic zone, as well as generally the principles that apply to maritime delimitation. So of course, the North Sea continental shelf of 1969, followed by the various decisions in the 1980s, like Tunisia, Libya, Malta. In the sense they were conterminous with the developments of the entire regime of the UN Convention on the Law of the Sea. And in respect of delimitation, that ended up being a situation where the court has quite a few, quite a know-how, developed quite a know-how. But more and more you see the cross-fertilization between the court and ITLOS, where you see the court citing and relying on some ITLOS cases, of course, as limited as they are. For example, the references in the Nicaragua-Colombia case to some ITLOS jurisprudence. And then, of course, the ITLOS itself relying also on the same principles applicable to maritime delimitation as established by the ICJ. I think in the long term, we might witness more of an equitable sharing of cases between ITLOS and the ICJ. As you know, right now we have the Mauritius Maldives case pending before ITLOS. And I think going forward, of course, we have, as you know very well, we have witnessed the development of the jurisprudence, which kind of culminated with the 2009 Romania-Ukraine decision. But that being said, even if ITLOS has had less cases, it has made some very significant contribution to our understanding of maritime delimitation, in particular in respect of the continental shelf beyond 200 nautical miles. That's what it did in Bangladesh, Myanmar. And more generally, if you look into the jurisprudence of ITLOS, it has very much aligned itself with that of the ICJ. I think there is down the line, there's going to be change, but for the time being, perhaps states feel that there is greater know-how, if you wish, just simply by looking at the sheer amount of cases that the court has done. But I don't think it can be explained by anything other than that, other than pure perception. Because in reality, both institutions have done extremely well in their delimitation cases with a very thorough analysis and applying pretty much the same approach. That's what I would say.
Thank you, Vladyslav. Unfortunately, we are running out of time. I received a question whether it would be possible for you to share your email. I guess a lot of the participants would like to reach out to you with further questions.
I would love that, and I'm sorry that in the end I ended up taking a little bit longer talking, but I would be very happy to.
Well, you can always join us later for a second installment a few months from now. So can you give us your email?
Yes, of course. Shall I just put it in the chat?
Yeah.
Yes, and I can put to everyone in the meeting. Okay. Giving both of them just in case.
Okay, excellent. Thank you so much once again. Thanks, Vladyslav. Thank you to all of the participants. And as I mentioned, I hope we will be able to have a second installment The International Tribunal for the Law of the Sea is not a topic that we normally hear a lot about, but it has attracted a lot of interest, and so I hope that in the future you can spare a bit more of your time to talk about this fascinating topic. Thank you so much, everyone. Stay safe, and I hope to see you soon.
Thank you. Thank you all so much. Bye-bye.
Thank you.